to go first.
Okay, that's fine by me.
Thank you, Your Honor.
All right, so let's bring up on the male side, Mr. Bush and Mr. Sebring. Okay, so Mr. Bush, would you raise your hand for me, please, so I can know who I'm talking to? Thank you, sir. Mr. Bush and Mr. Sebring, you both are here on what's called the Fugitive from Justice warrant. And what it basically means is that we're holding you for another state. And for Mr. Bush, we're holding you for, it says Bay County Sheriff's Office. And there's a warrant for your arrest for forgery. And it's a felony, and they said that they will extradite you. Mr. Sebring, it says that you are here on a warrant from Clay County Sheriff's Office for failure to appear on a traffic offense. And they indicated that they will indict you or extradite you, sorry. So for both of you gentlemen, basically, you have two options. If you believe that you're not the person named in the warrant, or the warrant does not name an offense that can be prosecuted under the laws of that state, you can challenge that warrant. And if you challenge that warrant sometime between now and the next 90 days, there will be a hearing held here in Clayton County. And the purpose for that hearing will be to determine whether you are the person named in the warrant and whether the warrant actually shows a crime. We are not here to determine whether you're guilty or innocent of the charges. If you choose to fight it, you have 90 days, and there will be a hearing held within that 90 days. If at that hearing, the judge determines that you are the person named in the warrant and that the warrant does actually show a crime, judge will sign off on the warrant. And from that point, the requesting jurisdiction will have 30 days initially, and it could get extended to up to 60 days to come and get you. If you believe that you are the person named in the warrant and you believe that the charges are valid, you can waive that. And if you waive it, that 30 to 60 day clock begins to run today. And if they don't come and get you within the time period, you will be released out of the front door of the sheriff's department. But the warrant will not go away. So if you encounter a police officer 5 minutes after leaving the sheriff's department, and that police officer runs your information and the warrant pops up, the whole process starts all over again. So you have to kind of weigh whether it's good or bad in either of your instances. What I would encourage you to do, both of you, is to get a lawyer in the requesting jurisdictions, especially because of COVID. I've seen a lot of instances where once a lawyer gets involved, the state prosecutor will agree to remove the warrant with the promise that that person is going to appear in court. And it's not something that I can tell you will happen, but I've seen it happen. Mr. Bush, are you with me so far?
Yes, sir.
And Mr. Sebring, are you with me so far?
Yes, sir.
Have you thought about this and decided what you want to do, Mr. Bush?
Yes, I'm ready just to get away, just go to Florida. That's all I'm trying to see. Take care of this matter. I'm just trying to get away. Cause I just got released yesterday and they said I had a warrant, so I'm ready to go to wherever they trying to tell me I got a warrant to fast. And I gotta get a lawyer, you say, to do that, to leave, right? To make it a little faster.
Well, you have a right to a lawyer. And having a lawyer to act on your behalf generally moves this process along a lot faster. Because prosecutor is not allowed to speak to you directly under ethical rules. But if a lawyer is there, it can be a wide-ranging conversation. So, Mr. Bush, based upon what you said, I'm going to allow you to sign the waiver forms. They'll send them to me, and I'll sign off on them today, and that clock will begin to run today. But it's in your best interest to try to get a lawyer to deal with this. Yes, sir.
Here, I need a lawyer to hear down there, find a lawyer down there.
Down there.
Correct.
Yes, down there. Mr. Sebring, have you thought about this, and do you have sort of, first, any questions, but two, do you know what you want to do?
It's a simple traffic situation. I ran a red light. I actually missed the court date, so I'm just gonna sign the waiver, and prayerfully they'll come get me in the next couple of days so we can resolve this issue.
And there's and they some jurisdictions do it quick, some jurisdictions do it slow. So I can't give you a promise, but generally they will come and get you pretty quickly. But again, you also should hire a lawyer to help deal with this matter so that you can not just be, I won't call it lost in the system, but that you won't just be floating out there.
Yes, sir.
Okay. All right.
Yes, sir.
So both of you, once you sign your waivers, you can go back and I'll get those copies and I'll sign them today, and the clock will begin to run today.
I appreciate your time.
Thank you.
Thank you, Your Honor.
Thank you. So I'm gonna read the script and we'll get started on the ladies' side. Okay, good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner. I am a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf, or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You receive notice at the address you give of your next date. Finally, I need everyone to raise your right hand for me, please. Do you swear affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God? Okay, let's begin on the ladies' side. With Miss Bostic. Okay, Miss Bostic, ma'am, you're charged with one count of criminal damage to property in the second degree. This is a felony offense. Your bond is going to be set at $5,000, and there's going to be a stay away provision on your bond to stay away from a Richard Hilton. Do you understand that, ma'am?
Yes.
Your preliminary hearing date is going to be set for August 29th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, I was trying to see if I could get a OR bond or get a lower funding because I doesn't have a job and I have 3 kids. And I just want my kids with him.
Your husband is a victim in this case,
That's
correct?
not my husband.
I'm sorry, ma'am.
That's not my husband.
Okay, you said your husband did not have a job or
That's-
does not?
That's my kid's father. That's not my husband. I'm not married.
Okay, Mr. Hilton is your kid's father. And the allegation is that you believe that he was cheating on you, so you destroyed property within the home?
No, I didn't do well.
And I'm not asking you to agree or to defend yourself because you are innocent as you stand here. But you asked me the question about an OR bond. So I'm digging a little deeper. So, ma'am, let me, I guess, phrase the question this way. The allegation is that there was some kind of dispute and property was damaged. How does that qualify you for an OR bond?
That's I don't know.
So, and what I mean by that, ma'am, is that OR bonds are not to be given out like mint candy. Based upon the allegation, if you believe that this person was cheating on you, you could have walked out the house and gone and sat at a bar, gone to Waffle House.
Well, if I had tried to do that, it was gonna be a fight still. I mean, he hit me first, so it really, that's what, he shouldn't even put his hands on me is the point.
Well, no adult should put their hands on any other adult in a manner that that person has not consented to.
Sure.
So, Ms. Bossy, I'm going to deny your request for an OR bond. And just so you know, the process for granting an OR bond, there's only one person that can grant that, and that's my boss. And my boss is going to be out of town beginning tomorrow. So if you wanted me to request an OR bond, I would have to continue you over till tomorrow. So you have to stay in jail for another night.
But can I ask another question? Just,
I will allow you to do that, but just let me finish. Because I'm responding to questions that you've asked. I would have to speak to my boss about your case. She would review your criminal history and she would make a determination as to whether she believes that an OR bond is appropriate. And she may say no. And I'll tell you the basic guidelines that I'm aware of is basically college students, with they got marijuana or something. Those are the people that are considered OR bond worthy. People committing acts against other persons are not necessarily considered OR bond worthy. So what was your question, ma'am?
I thought I had a bond for 744, but you told me something different.
Yes, I did. There's criminal damage to property in the second degree as a felony offense. I don't know who coded that in at the 744 amount, but these offenses, this offense is only, bond can only be set by a judge. So that was an error. I mean, it was in your interest. Had you bonded out, I couldn't do anything about it, but you didn't bond out. So now I can do something about it. Any other questions, ma'am? Okay, ma'am, you're free to go back. Miss, who's this? Burks. Miss Burks, ma'am, you're charged one count of simple battery. Actually, battery. Family violence. But I'm going to set the bond at the simple battery rate of $3,000. There's going to be a stay away provision on the bond, stay away from a Roshunda Gardner. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for August 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay, if you do qualify, ma'am, I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, I don't.
Okay, ma'am, you're free to go back.
All right, thank you.
You're welcome. Miss Carmichael.
Yes, sir.
Ms. Carmichael, you're charged with several traffic-related offenses, so give me a moment. You're charged with one count of reckless driving, which is a misdemeanor offense. Bond is going to be set at $1,500. You're charged with one count of driving on the wrong side of the road. Bond is going to be set at $500. One count of driving a vehicle with an expired or invalid tag. Bond is going to also be set at $500. One count of improper passing on the left. Bond is going to be set at $500. One count of driving too fast for conditions. Bond is going to be set at $500. One count of obstructing an officer. Bond is going to be set at $2,000. One count of theft by receiving stolen property. Bond is going to be set at $2,000. One count of possession of a weapon during the commission of a crime. Bond is going to be set at $5,000. One count of possession of a firearm by a convicted felon. Bond is going to be set at $5,000. And one count of simple possession of a controlled substance. Bond is going to be set at $3,000. Because you have some felony offenses listed here, your preliminary hearing date is going to be set for August 29th at 8:30 in the morning. The date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Yeah. You do qualify, Ms. Carmichael. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir. I appreciate you.
Okay, ma'am, you're free to go back. Miss Mathis. Miss Mathis, ma'am, you've been charged with one count of cruelty to children in the first degree, which is a felony offense. And you're also charged with one count of battery. Bond is going to be set at $5,000 on the cruelty to children in the first degree and $5,000 on the battery. There's going to be a stay away provision on this bond, to stay away from a Christiana Sherman. Do you understand that, ma'am?
That's my child.
I'm sorry, ma'am.
My child.
Okay. Your preliminary hearing date is going to be set for August 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. Okay, ma'am, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes. How I'm gonna stay away from my child when I don't have no family here? It's just me and my kids.
Right now, ma'am, your child is listed as the victim in a case, and you are the alleged offender. And the purpose of placing the stay away provision on the bond, I don't particularly like it, but I understand the reason for it. I think in the 2 days this week, I've had 3 cases where mothers are beating on their kids, fighting them like adults. And I don't understand that. But we place these provisions on so that whatever happened the night before does not rise to the level of the police need to be called out. If you believe your daughter's being unruly, make a referral to DFACS. And most children, if given the opportunity to live at home or live in a group home situation with DFACS, would choose to be at home and to abide by the rules that are set by the parent. But I can't parent your child from here. So there are options available to you that are way below the threshold of fighting your child as an adult. Okay, ma'am? Any other questions?
No, sir.
Okay, ma'am, you're free to go back. Let's see, who do we have next? Miss Powell.
Yes, Your Honor.
Miss Powell, ma'am, you've been charged. Hold on, give me 1 second, I'm sorry. Okay, ma'am, I'm sorry. I'm getting older. My eyesight is failing me. Miss Powell, have you made bond, or do you know if family members have made your bond?
My mom told me that she is processing currently. That was about 3 hours ago when I gave her a phone call.
Okay, so it looks like your file has been sent over to bonding.
Okay.
And that happens, as you can imagine, with the number of people. I think we have 33 or 34 people on this calendar. So it takes time to move people back and forth. So it looks like you may have been caught in the middle of that. When you go back to your holding cell, they're most likely gonna let you know that your bond has been set and to pack your stuff so you can go.
Okay.
Okay, ma'am?
Sure.
All right, you're free to go back.
Thank you.
You're welcome. Miss Robbins. Miss Robbins, ma'am, you've been charged with 1 count of simple possession of a controlled substance. That's a felony offense. Bond is going to be set at $3,000. You're also charged with 1 count of criminal trespass, which is a misdemeanor, and bond is going to be set at $1,000. There's going to be a preliminary hearing date set for August 29th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry, ma'am. Okay. Okay, ma'am, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions for me? I'm sorry.
I'm recording. 29th.
I'm sorry. Can you repeat that?
She's asking when her court date is 29th, correct?
The 29th, yes, but that date will get waived when you bond out. And just so you know, ma'am, what basically happens is that when you bond out, your file gets sent over to state court. Well, it'll be Superior Court. And then it'll get assigned to a judge. And then you'll be on that judge's calendar. And I don't know what judge you're gonna get, so I can't tell you any future dates. Okay. Anything else, man? Okay, you're free to go back. Miss Robinson.
Yes, sir.
Okay, ma'am, you've been charged with 1 count of trafficking marijuana. I am not allowed to set bond on your case at this time. Any alleged amount of marijuana over 10 pounds is considered trafficking, and I cannot set bond. It has to be set on another date. You're going to have a preliminary hearing date that's going to be set for August 29th at 8:30 in the morning. You're going to have a bond hearing date that's going to be set for September 2nd at 8:30 in the morning. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Okay, ma'am, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
When is the first court date again?
August 29th
Thank you.
at 8:30 in the morning. Okay, ma'am, you're free to go back. Miss Samuel.
Yes, sir.
Ma'am, you've been charged with 1 count of driving a vehicle without a valid license. Bond is set by schedule, which means it's automatically set at $1,000. It's a misdemeanor offense. You're going to have a preliminary hearing date set for August 30th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
All right, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, I just wanted to ask, did you see my bond in the system? Because my bond was paid like at 3 o'clock this morning.
Okay. So I don't have access to that. That's I believe a part of the sheriff's department system. So if your bond was paid, like the other young lady, once you go back to your dorm, you're probably going to receive notice pretty quickly to pack your stuff so you can go home.
Okay.
Okay, ma'am, you're free to go back. Miss, is it Tupalisa?
It's Sayona.
Okay. Ma'am, you're also charged with 1 count of trafficking marijuana. And as to other person, I cannot set bond for this offense at this hearing. So you're going to have a preliminary hearing date set for August 29th. And just so you know, the bond is being denied under the statute, Georgia statute, OCGA 17-6-1. You're going to have a preliminary hearing date set for August 29th at 8:30 in the morning. You're going to also have a bond hearing date set for September 2nd of 2022. And it's going to be at 8:30 in the morning. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, Your Honor.
Okay, ma'am. You're free to go back.
Thank you.
Miss Jones?
Your Honor, I don't have a Ms. Jones here.
Okay. That was supposed to be an add-on from yesterday. I'll do a continuance order for her.
Your Honor, we'll go get her.
Okay. All right.
We
Well,
could
just yeah, so just hang loose, and when she comes back up, just turn your camera on, let me know, and I'll deal with her, Deputy Dunbar.
Yes, sir.
Thank you.
Hey, John Bar, take a chat.
Mr. Bell,
Yes, sir.
sir, you charge one battery. This is misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on the bond, stay away from a Christopher Franklin. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for August 30th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Bell. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Yes, sir.
Okay, you're free to go back, Mr. Bell. Mr. Cardenas.
Oh, he just stepped out, Your Honor. Can we go with Mr. Fry next?
Sure. Well, Duran, do you have Duran there, or has Duran bonded out?
Yes, he's here.
Okay. Let's bring up Mr. Duran. Mr. Duran, sir, you're charged one count of child abandonment. This is a misdemeanor offense. Bond is going to be set at $1,500. You're going to have a preliminary hearing date set for August 30th. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Durant.
Thank you.
Mr. Flanagan. Mr. Flanagan, sir, you're charged with one count of cruelty to children in the first degree. That's a felony offense. Bond is going to be set at $5,000. You're also charged with one count of simple battery. Bond is going to be set at $3,000. There's going to be a stay away provision on the bond, stay away from a Deanna Flanagan. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for August 29th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you will receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Are you currently working?
Yes, sir.
How much do you earn per hour?
I don't get paid off hour. I get paid off percentage.
You get paid off of what?
Off a percentage.
Percentage.
Yes, sir.
How much do you estimate that you make in a month?
Somewhere between about 3,500, between 3,000 and 4.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Flanagan.
Thank you.
You're welcome. Mr. Fryer. Mr. Fryer, sir, you're charged with 1 count of simple battery. Bond's going to be set at $3,000. You're also charged with 1 count of criminal trespass, damage to property as a misdemeanor. And hold on 1 second, I'm sorry. Bond is going to be set at $2,000. So you're going to have a total bond of $5,000. There's going to be a stay away condition based upon placed on this bond to stay away from a Jerisha Morton. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for August 30th at 8:30 in the morning, courtroom 201. That date will get waived upon the bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Fryer. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Fryer. Mr. Funderburg.
Your Honor,
Yes,
I do have a here whenever you're ready for it.
Miss Jones. Okay, stand by, Mr. Funderburg. Let's bring up Miss Jones.
Wait, no, sir, no, no. No, sir.
Uh-oh. Miss Jones, good morning, ma'am. My name is Brad Gardner. I'm the magistrate court judge presiding over the first appearance hearing today. It appears that you were continued from yesterday to today. You're charged with 1 count of criminal trespass, which is a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Jontai Jones. Do you understand that? I'm sorry, ma'am.
Yes, sir.
Okay. Your preliminary hearing date is going to be set for August 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, ma'am?
Sir.
I'm sorry, ma'am. About how much do you make per hour?
He says he doesn't work, Your Honor.
She does not?
Yes, sir.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay. All right, ma'am. You're free to go back.
Okay. Your Honor, I believe that was 2 females. Are we, may I be excused?
Yes, sir. Thank you for your assistance. Okay, we were on Mr. Funderburg. Can we bring Mr. Funderburg back up, sir? You're charged with 1 count of theft by receiving stolen property as a felony offense. Bond is going to be set at $10,000, and 1 count of possession of a weapon during the commission of a crime. Bond is going to be set at $10,000. So you're going to have a total bond set at $20,000. These are both felony offenses. So your preliminary hearing date is going to be set for August 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sir.
About how much you make per hour?
I said, no, sir.
Oh, no, sir. Okay. Do you have any questions for me?
No, sir.
Okay. You're free to go back, Mr. Funderburg. Mr. Holliday.
Right?
Mr. Holliday, sir, you've been charged with 1 count of
My name is Denzel Cardenas.
Cardenas. Okay. Mr. Cardenas.
Yes, sir.
Sir, you've been charged with 1 count of terroristic threats or acts as a misdemeanor offense. Bond is going to be set at $3,000, and you're charged at 1 count of obstructing an officer. Bond is going to be set at $2,000. Your preliminary hearing date is going to be set for August 30th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, Mr. Cardenas, I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I got one question. You say my bond altogether is $6,000?
5,000.
Yes, sir. Thank you. That's it.
Yes, sir. Okay, you're free to go back.
Sir.
Mr. Holliday? Mr. Holliday, sir, you've been charged with 1 count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision placed on this bond to stay away from a Christopher Franklin. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for August 30th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Holliday. I'm going to appoint a lawyer to represent you. Do you have any questions for me? I'm sorry, sir.
Sir.
Okay, you're free to go back. Mr. Johnson. Amin Johnson.
Sir.
Mr. Johnson, sir, you've been charged with 1 count of criminal damage to property. A criminal trespass damage to property is a misdemeanor offense. Bond is going to be set at $3,000 for this offense. There's going to be a stay away provision on the bond to stay away from a Nia Blake. Do you understand that, sir? Your preliminary hearing date is going to be set for August 30th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. I see that you refuse to fill out the form. Does that mean you're going to hire your own lawyer?
No, because I know what happened, and I just don't need a lawyer. So,
Okay. Okay, you don't have to explain that to me. You have the absolute right to represent yourself and conduct your defense in whatever manner you deem to be appropriate. Do you have any questions?
No, sir.
Okay,
Thank you.
Mr. Johnson, you're free to go back. Mr. Knox.
How you doing, sir?
I'm doing well. Mr. Knox, sir, you've been charged with 1 count of deposit account fraud. I've set the bond at $10,000. This is a felony offense. Your preliminary hearing date is going to be set for August 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah, yes, yes.
Okay, you do qualify, Mr. Knox. I'm going to appoint a lawyer to represent you. And I just want you to know, I did read the information that you placed on your form. You need to tell your lawyer that information so that your lawyer can defend you. You have any questions for me?
I know.
Okay, sir, you're free to go back. Mr. Leon.
Sir,
Good morning, Mr. Leon. Sir, you're charged with 1 count of simple possession of a controlled substance. That's a felony offense. Bond is going to be set at $3,000. You're also charged with misdemeanor possession of marijuana. Bond is going to be set at $1,500. 1 count of having it says dangerous drug, but basically a controlled substance that's a pill that's outside of the container. I've set the bond at $1,000 for that.
yes, sir.
And you're charged with 1 count of failure to yield when entering a roadway. Bond is going to be set at $500. Because of the felony offense, you're going to have a preliminary hearing date set for August 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. And I have something I want to just talk to you about against 2 of the charges that I had been charged with when you were saying about the pill, one of the pill in the bottle. But that was in my car as an old 97 Toyota Camry. But anyway, that was muscle spasm pills that I was taking, but that was for an accident I was in a couple of car accidents like about 2-3 years ago. I don't do the pills. I don't abuse no pills. And that's
So,
the truth.
so Mr. Leon, there currently is a gap in the law. You can be prescribed a pill that you're supposed to take, or pills.
Yes, sir.
That you're supposed to take during the day.
Yes, sir.
Taking the pills out of the little bottle with the prescription on it, and you can place it in one of these containers that say Monday, Tuesday, Wednesday, Thursday, Friday, that kind of thing. Hold on, sir, I'm gonna let you speak.
I'm understanding you very well.
It gets converted to a crime just by doing it.
Okay, I understand. But the pills that I had that he was talking about, these was muscle spasm pills. This ain't had nothing to do with no pill. And we talked about it too. And the pill, it was in a bottle and it had my name, my address, everything on it. I told him I live at 8965 Ashton Road, Jonesboro, Georgia, and everything else. And that was the address where I live at that was on the bottle. Now the one thing about the marijuana, I did discuss.
No, I don't want to hear that. I don't want to hear that. Talk to your lawyer.
Sorry.
This is just so you understand.
Okay,
this is stop, sir, please.
Yes, sir.
This is being recorded.
I'm sorry.
So don't make any admissions.
Okay.
And you're basically killing your case before the lawyer ever gets a chance to look at it.
Yes, sir.
Okay.
Yes,
So
sir.
you need to just speak to your lawyer about the facts and circumstances of your arrest.
Yes, sir.
I said at the beginning, I'm not having a trial of the case today. I'm not taking pleas
Yes,
today.
sir.
So just take that information that you have, provide it to your lawyer, and you may be pleasantly surprised by the result.
Thank you.
Okay. All right, sir. You're free to go back. Mr. Martin. Mr. Martin, sir, you're charged with 1 count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Christopher Franklin. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for August 30th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Percy.
Yes, Your Honor.
Mr. Percy, sir, you're charged with 1 count of misdemeanor possession of marijuana. Bond is going to be set at $1,500. Charge of 1 count of speeding. Bond is going to be set at $500. 1 count of driving a vehicle with no insurance. Bond is going to be set at $1,000. And 1 count of an open container violation. Bond is going to be set at $500. These are all misdemeanor offenses, so you're going to have a preliminary hearing date set for August 30th at 8:30 in the morning. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
You do qualify, Mr. Percy. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, so I do have bail then, right? I can bail out.
Yes, sir.
Okay, thank you. That's it.
Okay, you're free to go back. Mr. Ortega. Mr. Ortega, sir, you're charged with 1 count of simple battery. Bond's going to be set at $3,000. There's going to be a stay away provision on the bond, a stay away from a Kimberly Diaz or Diaz. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for August 30th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. You didn't fill out the form. Does that mean you're going to hire your own lawyer? You're going to represent yourself?
I'll hire my own lawyer.
Okay. Do you have any questions for me, Mr. Ortega?
No, sir.
Okay, sir. You're free to go back. Mr. Powell. I'm doing well, Mr. Powell. Sir, you're charged with a number of driving related and drug offenses. So you're charged in warrant number ending in 5-1 for violation of Georgia Controlled Substance Act, simple possession. This bond is going to be set at $3,000. And the warrant ending in 5-2, you're also charged with simple possession of a controlled substance. Bond is going to be set at $3,000. You're charged with driving a vehicle with no insurance. Bond is going to be set at $1,000. You're charged with warrant number ending in 5-4 with simple possession of a controlled substance. Bond is going to be set at $3,000. You're charged with 1 count of use of possession of drug-related objects. Bond is going to be set at $1,500. and running a red light, bond is going to be set at $500. Knowingly driving a vehicle with the council registration, bond is going to be set at $500. And driving a vehicle without a valid license, bond is going to be set at $1,000. Because of the felony offenses, you're going to have a preliminary hearing date set for August 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
About how much do you make per hour?
$12.50.
Okay, you do qualify for a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. What was the felony charge?
The drug offenses are the felony charges. The THC oil, that's classified currently under Georgia law as a felony.
All right, so with it being in the truck, then that automatically prove it was mine.
I understood with it being the truck, but I didn't understand what came after truck.
Oh, well, I'm saying with the THC oil being inside the truck, mind you, the truck ain't mine. It was like my friend girl's type shit, and I ain't know it was in there.
So that's where, well, that statement is why we appoint lawyers as quickly as possible.
Yes, sir.
You should speak to your lawyer about that, because based upon the facts and circumstances, the lawyer may be able to get those charges dismissed.
Yes, sir.
Anything else, Mr. Powell?
No, thank you.
Okay, sir, you're free to go back. Mr. Prater.
Sir.
Mr. Prater, sir, you're charged with 1 count of criminal trespass. Bond's going to be set at $3,000. This is a misdemeanor offense.
Sure.
Your preliminary hearing date is going to be set for August 30th of this year. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, sir.
You said no?
You don't have to. I'll try to get one. I'll try to get one.
And I'm sorry, because there's some background noise, so it's hard for me to understand you. So could you just say no or yes? Do you want me to see if you qualify for the appointment of a lawyer?
Yes, you can. Yes.
Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Prater. Mr. Rawls. Mr. Rawls, sir, you're charged with 1 count of trafficking marijuana. This is an offense that I cannot set bond at this stage. So bond is going to be denied pursuant to Georgia statute OCGA 17-6-1. You're going to have a preliminary hearing date set for August 29th at 8:30 in the morning. And you refuse to fill out the form. Does that mean you're going to hire your own lawyer?
Sure.
Okay. Do you have any questions of me, sir?
Will there be a bond hearing at all?
Bond hearing is going to be set for September 2nd at 8:30 in the morning. Your lawyer may be able to negotiate with the district attorney's office as to a consent bond. So if they're able to do that between now and August 29th, your case will get sent bound over is the terminology, but it will get sent to the Superior Court of Clayton County. Do you have any questions for me, sir?
So you said I can speak to a lawyer to get what? what type of bond is that you said, sir?
So your lawyer may be able to meet with the district attorney's office between now and those dates that I set out. And they may reach an agreement as it relates to your bond. And if they do, they'll send over a consent bond order. One of the judges will sign it, and then you will be able to bond yourself out.
All right, thank you, sir. No more questions.
Okay, you're free to go back. Mr. Ruth. Are you Mr. Jeffrey Ruth?
Yes, sir.
Okay, sir, you're charged with one count of driving a vehicle without a valid license. Bond is set by schedule, which means it's automatically set at $1,000. You're gonna have a preliminary hearing date set for August 30th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, Mr. Ruth. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
All right, you're free to go back. Mr. Thomas. Mr. Thomas, sir, you're charged with one count of criminal trespass. This is a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on the bond, stay away from a Preston Weaver. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for August 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay. You plan on hiring your own lawyer, or representing yourself?
Represent myself.
Okay. Do you have any questions for me, Mr. Thomas? Okay. You're free to go back, sir. Mr. Watkins.
Sir.
Mr. Watkins, you're charged with a number of offenses that I cannot set bail for at this stage. So aggravated assault, warrant number ending in 32, bond is going to be denied. Battery, bond is going to be set, that's a misdemeanor, bond is going to be set at $5,000. Aggravated assault with a deadly weapon, warrant number ending in 65, bond is going to be denied. Violation of Georgia's Firearms and Weapons Act, that's also a felony. Bond is going to be denied. That warrant ends in 66. And you charged with one count of murder, felony murder. And warrant ends in 67. Bond is going to be denied pursuant to Georgia statute 17-6-1. Your preliminary hearing date is going to be set for August 29th at 8:30 in the morning. Your bond hearing date is going to have to be given to you at a later date because it's going to have to be a Superior Court judge who's presiding for either this month or next month. And we're going to have to check with their schedule to see when they can have a bond hearing. You refuse to fill out the form. Does that mean you're going to hire your own lawyer?
That was a plan, but can you hire me? Can you for?
Okay. Are you currently working, Mr. Watkins? I'm sorry, sir.
I was in school. I wasn't working. I was getting refund checks through school.
Okay. So I'm going to find that you do qualify for the appointment of a lawyer. If you decide to hire your own lawyer, just let the lawyer know that that has been appointed to you. and that lawyer will withdraw from your case, and the new lawyer will step in.
Yes, sir.
Do you have any questions for me, Mr. Watkins?
Sir, thank you, sir.
Okay, you're free to go back. Mr. White. Mr. White, sir, you're charged with 1 count of possession of marijuana less than an ounce. That's a misdemeanor. Bond's going to take $1,500. You're charged with 1 count of improper lane change. Bond is going to be set at $500, and 1 count of driving a vehicle that you did not have the proper classification on your license to drive. Bond is set at $500.
So
Hold on, sir. Hold on. As you've heard, my last question is are there any questions? So I'll sit and listen. Because these are all misdemeanors, your preliminary hearing date is going to be set for August 30th. That date will get waived upon your bonding out, and you'll get a new court date in the mail. I see you refuse to fill out the form. Does that mean you're going to hire your own lawyer?
I ain't gonna do no lawyer. I'm gonna represent myself.
Okay. Now, do you have any questions for me, Mr. White?
When I was driving the vehicle, I had a permit. I had an instructional permit, but it's still valid. Like the date is still valid. That don't matter. I was going to work, and they said I can drive to work with my permit.
So, Mr. White, I cannot conduct a trial of your case right now.
I got you for sure.
And so those are all valid issues. And make sure that if you're going to represent yourself, that you have all the necessary documents, evidence, and information to show your point. Okay.
Right.
Anything else, sir?
One more question. No, they gotta read me my Miranda rights. They gotta read me my Miranda rights when they arrest me, right?
No.
They don't have to.
No, so listen, Miranda, if they're going to use any statements that you have made against you, they have to read your Miranda rights first. But there are exceptions to that, because there's, for example, that one is called an excited utterance. Soon as the officer walk up, you say, "Hey, this was my car," or "Yeah, I took the car. I did this." And so any statement that you make that's not in response to questioning can potentially be used against you, but it's a case-by-case basis. Okay, sir? Anything else, sir?
You know if somebody processed the bond, right? You know when the bond is processing, right?
No, sir. Let's see. So your bonds are set by schedule, which means you don't even have to come before a judge. If through a bonding company or whomever else, someone can just go ahead and make arrangements with the sheriff's department to bond you out.
That's cool.
Okay. Anything else, sir?
You said how much was all mine in total? My charge in total?
Looks like $2,500.
All right, that's it. That's it.
Okay, sir, you're free to go back. Mr. Wilson. Mr. Wilson, sir, you charge a 1 count of battery. Bond is going to be set at $5,000, and you're charged with 1 count of simple battery. Bond is going to be set at $3,000. These are both misdemeanor offenses. Your preliminary hearing date is going to be set for August 30th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, Mr. Wilson. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
My bail can be paid online, correct?
I'm sorry.
Will my bail be paid online?
That's a question better suited to the sheriff's department as to how they accept payment of bonds, because I honestly don't know.
Okay. No more questions, Your Honor. Thank you.
Okay, sir, you're free to go back.
Have a great day.
You too. All right, we made it through another day, Deputy Requena.
Sir, that's gonna be everybody on the calendar, Your Honor.
And I haven't called you detective in the past 2 days.
It's all right.